5 years, no trial, no bail. When bail stops being the rule. No relief for Umar and Sharjeel. Convicted godman out again. Convicts on parole, under trials in jail. Bail for Gurmeet, jail for Umar and Sharjeel. Criminal justice system broken.
All right, let's take you to our top story right now. 5 years, no trial yet, no charges framed, and today the top court of the country denied bail to Sharjeel Imam and Umar Khalid, leading to widespread debate. That's how it panned out.
"5 years in jail, no conviction, no trial, no bail. Pre-trial detention continues. Does the dictum bail being the rule, jail the exception not apply?" On Monday, the Supreme Court denied bail to jailed student activists Sharjeel Imam and Umar Khalid in a UAPA case linked to an alleged larger conspiracy behind the 2020 North-East Delhi riots. The bench comprising Justices Aravind Kumar and Anjaria also delivered its judgment on the bail pleas filed by Gulfisha Fatima, Meeran Haider, Shifa ur Rahman, Mohammad Salim Khan and Shadab Ahmed. These 5 accused were granted bail. The country's top court declined to grant bail to Umar Khalid and Sharjeel Imam, citing the gravity of the allegations and the stage of the trial. The bench made it clear that this is not the moment for relief. The court said that there was clear prima facie evidence of criminal conspiracy. The judges said liberty for bail under UAPA is different in the context of national security. The top court observed that all accused in the case can't be treated equally and that pre-trial detention can't be counted as punishment. The Supreme Court added that Umar Khalid and Sharjeel Imam can apply for bail again after the examination of all prosecution witnesses in the matter is completed or after 1 year, whichever comes first. The Delhi court argues that the accused were not mere participants but active players in a larger conspiracy, while the defense maintains there is no evidence linking them to any act of violence. Police further claim that the accused speeches contributed to the violence, a charge the defense rejects, saying the speeches are being misread as criminal intent. The prosecution also points out that several key witnesses are yet to depose. The defense counters that the trial is yet to begin even after 5 years. What many legal activists add is that the judgment is flawed, even if it's under the stringent charge of UAPA. As after 5 years of no trial, court arbitrarily says the accused must stay in jail for another year and then apply for bail. What is this 1 year going to achieve? Worse still, pre-trial detention is not seen as punishment. And this is where the public debate intensifies. While under trials remain in jail, Dera Sacha Sauda chief Gurmeet Ram Rahim, convicted in rape and murder cases, has been granted his 15th temporary release since 2017 through parole or furlough and will release again after 40 days. Each release justified under prison rules, each extension legally sanctioned. Since their arrests, Umar Khalid and Sharjeel Imam were free on bail for only 29 days compared to Gurmeet Ram Rahim, who was out on parole or furlough for 406 days. While Gurmeet Singh was convicted for rape of 2 women, Umar and Sharjeel, though charged under, are yet to see their trial begin. Different laws, different cases, different legal frameworks. But the comparison has ignited uncomfortable questions. Under trials wait, convicts walk out again and again. As legal distinctions clash with public perception, one question refuses to fade. Is India's judicial system structurally flawed, or is justice increasingly seen as unequal? Bureau Report, India Today.
All right, tracking the case very closely, my colleague Shrishti Oja joins us. She's been following the case of Sharjeel Imam as well as Umar Khalid over many years now. Shrishti, can you take us through On what grounds was bail denied? Till now, both Sharjeel as well as Umar Khalid have been collectively treated along with the 5 where charges were concerned, where conspiracy was concerned, yet a differentiator was made today.
Well, yes, Preeti, as we know, as far as the accused in this case are concerned, that constantly since the beginning argued that there has been a clear delay in investigation, trial, and in fact there's a lack of evidence to even invoke UAPA charges against the accused. On the other hand, the Delhi police has constantly claimed that there was a deep-rooted conspiracy and even a regime change operation as far as the 2020 Delhi riots are concerned. Now, today's Supreme Court order comes in as a relief for 5 accused who've gotten bail, but a major setback to 2 of these accused who, according to the Delhi police, are the main accused and conspirators, Umar Khalid and Sharjeel Imam. And how the Supreme Court has justified this differential treatment is by saying that they're not, as far as they cannot be treated on the same footing since their alleged roles in this case were different, which is why the alleged roles had to be examined accordingly for different accused. Let's quickly take a look at the main aspects that the court has dealt with in this order. Firstly, the threshold for bail under UAPA, according to the court, is very clearly way higher than the other offences. Secondly, according to the court, it's true that personal liberty matters, but not at the cost of national security. The court has very clearly said that when allegations of national security, sovereignty or integrity of a country are made, delay cannot operate as a trump card. If anything, it operates as a trigger for higher judicial scrutiny. Thirdly, we saw the top court get into the details of the allegations against Khalid and Imam, saying that the prosecution evidence and the material that they have placed before the court clearly makes a prima facie case and proves that they had a role in planning and organizing the Delhi riots. So as far as the arguments put forth by both sides are concerned, the Supreme Court's answer today is very clear. According to them, in UAPA cases, the bail threshold is higher. That's how they've justified not granting bail to 2 of the persons. Examination of individual roles of all the accused is extremely important. And thirdly, the material which prosecution places before the court gains extreme relevance because under UAPA, the court is required to examine the prosecution material and determine whether that material proves the offences which have been alleged by the prosecution against the accused. Over the last few years, we've seen this case, the Delhi riots case, been subject of many heated debates as far as the prolonged incarceration is concerned or the delay in trial or investigation is concerned. But the Supreme Court's answer today has been very clear, which basically ends in as relief for 5 accused, but as a major setback to Umar Khalid and Sharjeel Imam, who will have to wait for at least another year to be even able to apply for bail again before the trial court. Either that or they'll have to wait for the protected witnesses in this case to be examined by the Delhi police, whichever of these 2 happens earlier. After that, they will be at liberty to again approach the trial courts. So as of now, of course, the case is not over, the story is not over, but the battle will now again shift back to the trial courts as far as this case is concerned. Back to you.
All right, Shrishti, appreciate you joining us. I just want to put this in perspective, viewers, because we are standing in a place where both the individuals we speak of have been in jail for the last 5 years, of course, charged under UAPA, where trial hasn't technically begun, charges haven't yet been framed, and bail has been denied. I want to cut across to Mr. S.B. Raju, former ASG defense lawyer in case argued in court as well today. He was a defense lawyer, argued in court. Mr. Raju, thank you for taking the time out and joining us. On the technicality, Mr. Raju, that the bench today said that they can wait for a year to apply for bail. How does it even add up? Because Article 21, which guarantees liberty, does it automatically kick in after 1 year, which is not present today? It's been 5 years, they've been incarcerated.
It's not a question of Article 21 clicking in automatic. Am I audible?
Okay. You are audible, sir. Go ahead.
It's not a question of Article 21 clicking in later. Article 21 is always there. But you have to interpret, you can't interpret Article 21 arbitrarily. It has to be applied to the facts of the case, to the concerned accused, his role, and the nature of the offense. No doubt the offenses are very serious offenses. When you want to dismember India, separate Assam from India, and stop the essential supplies to Delhi and other parts, it's a very serious offense. So in a serious offense, and it's more serious because 53 persons were killed and more than 530 were injured. Okay, if that is the scenario, the main masterminds stand on a different footing. They can't ask for bail merely because the trial has been protracted or delayed. We have produced evidence to show that mainly the trial has been delayed because of the stand of the accused. They are asking adjournments. They are not making arguments. They are delaying the hearing of the discharge applications. If they are responsible for the delay, you can't say, oh, they are in jail for 5 years, grant them bail. That's not the law. If a person is guilty of delay, he can't take advantage of it. Therefore, the judgment is a very well written judgment. It's a balanced judgment. It takes into consideration national interest. It takes into consideration societal interest. And according to me, in a case like this, national interest and societal interest should prevail over individual interest. If there's no nation, where's the question of individual rights? These are the
That's a
persons who
matter
want
of
India to be cut to pieces.
fair point, sir. But that's a matter of a trial which needs to be proven in the court of law. The second question where you talk of where even the learned bench has claimed that both the individuals were on a different footing and cannot be clubbed with the 5 others who got bail today. But over the last 5 years, both these individuals have been treated collectively along with the other 5 as conspiracy. Suddenly, why is there a different footing now?
I have not read the judgment because I'm traveling. I'm actually at the airport right now. But the issue is this. Their role is totally different. It's not a collective role as such, but their role, they are the main masterminds. Therefore,
But the
the court
last
has
5 years,
segregated
sir, they
them.
had been treated collectively in the same group. Denied bail in the
Well,
same
all
group
accused are
as
treated
conspiracy,
collectively.
where
In a
all
criminal
7 were
trial, all
treated
accused, sorry
on the
to
same
say
footing?
that. In a
Go ahead,
criminal
sir.
trial, all accused are treated collectively, but they are punished separately. Treating collectively doesn't mean that they've been treated, not considered their individual roles separately. You can be treated collectively, but individual roles can also be considered separately. That's the issue. Okay. And the
Oh,
another
yeah.
point is this. There's no mathematical formula or arithmetical solution that 5 years bail. That's not the law. Supposing there's a serial killer, and if you release him after 5 years because in 5 years he's in jail, he will go on killing people. That's not the law that if you're in 5 years, you have to be granted bail. That's not the law. You have to look at the facts of the case on case-to-case basis. You have to decide, and that is what the court has done.
5 years incarcerated, the trial hasn't quite begun. Charges
All
haven't been
right, I'll
framed.
answer
Do
that.
you not reckon this is a blot on the judiciary in itself,
And
sir?
have you
Because
gone into
somewhere
the
down the line
question
it
as to why the
subverts,
trial? I'm sorry to
and
interrupt, but
undermines the presumption of innocence, which is the tenet of constitutional criminal law?
and innocence, yes, but as far as the UAP is concerned, there's a basic difference. At the time of granting of bail, the court has to consider whether there is a prima facie case. That is considered on the basis of evidence that is existing at the time of hearing of the bail application. It is not as if there is a mere allegation. There is evidence to the effect that these persons are guilty. If that is the evidence, they stand on a different footing because of Section 43D5 of the UAP Act. And delay is attributable to the accused. Many accused adopt tactics which would delay the trial because they know that they have a hopeless case. If the case proceeds on
How
merits,
can delay
they
be
will.
completely attributed
You're
to
not
the
allowing
accused,
me to
sir?
speak, ma'am. If you're not allowing me
Make your
to
point.
speak, that's
Make
not
your
fair.
point, sir. Of course, sir, make your point.
So there are accused who see to it that they have a bad case, so they'll delay the trial on one pretext or the other. Because if the trial proceeds, they're going to be convicted. The only way they will get out is on bail on the ground of delayed trial. But the delay in trial, if it is attributable to accused, they can't take advantage of it. That's plain and simple, ma'am.
How is it completely attributed to the accused, the delay in trial where the witnesses are yet to be
Yes, there's a
questioned
lengthy judgment
and
delivered. Lengthy
the
judgment
charges are
delivered
yet
by
to be
the Delhi
framed?
High Court. Yes. That means you've not read the facts of the case. The
Sir,
facts of
I've
the
just
case
read the order. Go ahead,
demonstrate,
sir.
yes, the facts of the case demonstrate that the accused are responsible for the delay. In fact, in a case, another case in the Delhi High Court, which is not subject matter of these cases, the Delhi High Court has ruled that these accused are responsible for the delay in trial, and that judgment is attained finality. So there's a judicial verdict stating that the mainly the delay in trial is attributable to the accused and not to the prosecution.
How, I just want to get a larger understanding, how are the accused responsible, sir, for the Delhi police not getting the not questioning the witnesses for the charges to be framed? How are the accused responsible for both?
Yes. I'll give you, I had argued this in length when I argued the matter. We are given a detailed submission on these points. One, the issue is they were supposed to argue on discharge. Their lawyers refused to argue on number of dates. And number of dates, the matter was not being argued. And they were finding pretexts saying, I'm not ready with the matter. Some other lawyer will argue, I'll not argue. You go through the record of the case, you'll get all the answers. I need not answer all these questions.
So I have gone through the record of the case. I understand with what you say. On multiple occasions, they did pull back the application. So yes, there is a bit of onus which lies on the accused. But having said that, how are the accused responsible for the Delhi police not being able to conduct investigations, question the witnesses, and frame charges? What part do the accused have in that?
Delhi police doesn't frame charges, ma'am.
No,
Delhi
sir.
police only submits the charge sheet.
Sir,
it was submitted.
Questioning the witnesses, sir, and the charges being framed in court.
The witnesses were examined. It is a case. It is a case of conspiracy. There are cases and cases. When you have to gather evidence, it takes time. It is not that they were whiling away and not doing anything. It's a lengthy case. Large number of witnesses were to be examined. The evidence was to be collected, and there were large number of cases. The police was also bogged down in the matter, but there is no delay as far as the police is concerned. As far as the investigation is concerned, I am talking of the situation post this charge sheet. Who is responsible for the delay? The delay is attributable to the accused and is demonstrated not by me, but by a judgment of the Delhi High Court.
On the August 13th, sir, there's a case, you know, because we're talking about the UAPA, my final two questions. On the August 13th, the bench of Justice Okha and George Massey of the Supreme Court had made it very clear where they had ruled bail is rule, jail is an exception, even in cases of UAPA. It's a fundamental right.
But there is another judgment which has taken a view that considering what does 43D5 say? 43D5 of the UAPA Act says that if there's a prima facie case, bail is not to be granted. So bail may be the rule, but not where there's a prima facie case. If there's a prima facie case, then bail is not a rule, but bail is an exception. That is what the law says. That is what
then how,
bare reading of section 43D5 says.
Then that's where the 1 year becomes relevant.
The rule
how does bail then? Because last two questions, sir. Because the court today also said that in 1 year, if the witnesses haven't been questioned, it's not been completed, they can come back for bail, whichever is earlier. Now, what will 1 year change?
I'll tell you what will change. 1 year, that the accused will now see to it that they cooperate and not delay the trial. Because even after 1 year, if they don't do anything and they keep taking dates, then the situation will not change. So they now realize that asking for dates, asking for adjournments will not lead us anywhere. Therefore, they will cooperate and see that the trial is conducted. Once the trial is conducted, if the Delhi police produces evidence and the evidence suggests that these two persons are involved or guilty, that we will have a better case. It doesn't mean that they will automatically be granted bail. Then it will be examined on the evidence, not only recorded during the investigation, but evidence which has been recorded in court. Therefore, the situation will be difficult. Maybe at that stage, if the evidence doesn't come forth, if the witnesses turn hostile, they may have a good case. But this is all in the realm of imagination.
The sheer fact that the UAPA is a draconian archaic law which has been contested in court, like the PMLA, and I'll maybe draw a parallel here, because the top court of the country in PMLA, which could have similar, you can draw a parallel with UAPA, did give bail in the case of Aravind Kejriwal and Manish Sisodia. That was a precedence. Today, with this case, are we also setting a precedence that will make it that much more difficult for anybody else facing a UAPA charge to get bail?
You can't compare UAPA with PMLA. It's like comparing apples with oranges. You can't compare an apple with orange. In the PMLA, the maximum sentence is 7 years. In UAPA, the maximum sentence is death. So first of all, you can't compare that. Secondly, as far as Aravind Kejriwal is concerned, the bail in the Supreme Court was on technical grounds of arrest, necessity of arrest, grounds of arrest. That was being challenged in Aravind Kejriwal's case.
So are you saying this will become a precedent in cases of UAPA? The denial of
Of
bail
course,
today?
every judgment of the Supreme Court is a precedent.
Exactly. So like
Every
PMLA,
judgment
this
of the
will also
Supreme
happen.
Court, as far as the
Okay.
law declared is concerned, is a precedent. I need not say that. It's the law of the land.
Okay.
That a judgment of the Supreme Court is a precedent binding to everybody. Of course, it is not binding. It is, if it is peculiar to the facts, it's not binding. But if it is
All right.
law declared, then the law declared is binding.
All right. I thank you, sir. Thank you for taking the time out and joining us. Appreciate it. A former ASG there, who also was the defense prosecution lawyer in this case, joining us live. I also have with me Dr. Ashwani Kumar, former law minister, joining us live. Dr. Kumar, appreciate you taking the time out. First up, so how do you read the judgment today, where bail granted to 5 other accused in the same case and 2 of them been denied bail?
Look, I must say that the judgment has been written with great felicity. I've had the occasion to just glance through some of the paragraphs which are relevant for this discussion. But I hasten to add that I'm unable to agree with the net result of what the Supreme Court says is a calibrated exercise of constitutional discretion. I think a constitutional court like the Supreme Court, which is a counter-majoritarian institution, is expected always to lean in favor of the libertarian conscience of the Constitution, namely Article 21. And that is what has been upheld in a series of judgments of the Supreme Court in special cases like the PMLA and even in UAPA. Of course, the statutory threshold of bail is different in these matters. But even so, the Supreme Court has, in a series of judgments, some of which you have pointed out to the earlier speaker, have said that Article 21 must prevail and that long incarceration is unconscionable by this command of the Constitution. That is what needs to be reiterated, and that is what you valiantly tried while questioning the other speaker. But I'm of the view that while it is not possible to say that the judgment is perverse, but if I were to be the judge of the Supreme Court in this case, I would lean in favor of liberty after 5 years of incarceration. And please remember, India is no banana republic. 2, 4, 10, 20, 30 people cannot really dismantle or disrupt the nation's unity and integrity. So therefore, I think a time has come for citizens to assert the constitutional conscience, and the time has come for the Supreme Court not to be overawed, if I may say so, with the utmost deference, by the routine invocation of national security as an argument to incarcerate individuals for unconscionably long periods. It does not gel with the republican conscience of a nation born to freedom and anchored in freedom.
You know, Dr. Kumar, I want to ask you and maybe get a larger understanding, because we were speaking to the prosecution lawyer, and he seemed to suggest that that 1 year period would maybe now hasten the accused to not delay the the trial, because that is the reasoning given why the trial has been delayed. Though I don't understand the connect with the witnesses not being questioned yet or the charges being framed.
Well, that's a very lame argument. I think it's impossible for any accused, when pitted against the might of the Indian state, to delay the trial. It is, of course, always possible for the prosecution to invoke several reasons why they have not been able to carry out the investigation, examine the witnesses, present their case for the charge sheet, etc., etc. I, for one, with my little experience at the bar, would be disinclined to believe that any accused is so resourceful or so ingenuous as to delay the case, because it is in their interest that the case ought not to be delayed and they should be out on bail. It is not in the interest of the accused to unconscionably delay the proceedings, although there may have been good reasons for them to have moved the applications before courts for various reasons. That's another matter. That is the right of the litigant. Now, to accuse the litigant of delaying the process for invoking his rights by moving a suitable or an appropriate application is not right. I am mindful of what the High Court has observed, but I think in balance, in the totality of the case at hand, which has which has really been a matter of great national interest, and rightly so, the incarceration of two individuals who have been treated differently merely on the ground that the materials show that they were the prime movers and not mere facilitators. That is the distinction that has been drawn between the two sets of accused. But I think in the totality of the circumstances, the bail ought not to have been withheld.
The other argument that was made, by the prosecution lawyer, sir, was the fact where it comes down to differentiating the two from the five others as they were on a different footing. Now, the argument is, Dr. Kumar, that over the last 5 years, they were in the same pool. It was a common conspiracy. When did they become masterminds? And when was a different footing attached to it? Because they were denied bail collectively. Over the last 5 years, they were treated as the same.
Well, it is always open to the court to weigh the role of different accused. That legal position is well settled. But the fact remains that even against the two principal accused, there has been a strong argument on their side, which one has been reading in the papers. I've not seen the case file in toto, but what has been argued on their behalf is that even the provisions of the UAPA under which they have been charged are not satisfied. And this judgment itself repeatedly says that this judgment is nowhere indicative of a prima facie finding of guilt. Now, if this judgment denying them bail is not a prima facie finding of their guilt, and rightly so it is not, then certainly this highest court of the land could then have leaned in favor of their liberty to say that they have been in prison for 5 long years. What happens if they are ultimately acquitted? Is there a recompense for the loss of liberty of the citizen?
Right.
So that ground itself should have prompted, in my view, and I may be wrong,
Right.
I say so with the utmost respect to the highest court, the libertarian conscience of the court should have leaned in favor of granting bail rather than rejecting bail.
All right. Appreciate you joining us, sir. Thank you there. So what one really needs to underline in this argument is Article 21, prolonged incarceration of both Khalid and Imam, undermining the presumption of innocence, which is the tenet when it comes to criminal law in this country. I want to cut across to our other guest joining me, Dushyant Dave, Senior Advocate, Supreme Court, Aman Lekhi, Senior Advocate, Supreme Court, Swapnil Kothari, Senior Lawyer, Supreme Court. Swapnil Kothari, I think, you just heard Dr. Ashwani Kumar. We had the defense lawyer, former ASG before that. Why do you think this judgment, because you seem to believe that this judgment is a very fair judgment. What are your arguments?
Good evening. I firmly believe that this judgment is a fair one. You cannot treat what Gurmeet Singh did of Dera Sacha Sauda with what Sharjeel Imam
but we're not treating that, Mr.
Umar
Kothari.
Khalid.
That's just, nobody's, okay, let's not compare the two. Let's just talk about this case and where Article 21 is concerned, where his presumption of innocence comes into question, where prolonged incarceration without trial, without the framing of charges comes into question.
Right.
Does it somewhere down the line challenge what is the principle of criminal law, which is the presumption of innocence?
Well, if you let me complete my point,
Ahead,
I just wanted to, I'm doing it for the benefit of the viewers, as you would appreciate, so that they understand the distinction between what one is on parole, where he's a convict. I do not agree with so many paroles and furloughs granted to him any which ways. But as far as coming to this case is concerned, Preeti, the point is that there is Article 21, but 43D5 of the UAPA is very clear that if there is a prima facie case, and the prosecutorial evidence suggested that there was a prima facie case, so obviously the bail cannot be granted. Bail is the rule and jail is the exception. But as far as the UAPA is concerned, which is a draconian law, which is a draconian legislation, and precisely why we need to have such legislations, because when you try to divide the country, when you try to attack the sovereignty and the unity of this country, when you try to do rasta roko, when you try to see to it that the essentials are not being given or should not be given, when you try to create some sort of a disharmony between religions and all of those things, and if there is evidence pointing to that fact, then there is definitely a case that is made out before the court of the land, and the Supreme Court clearly pointed out that, yes, these two have to be treated. Yes. And one of the points that you raised was a very valid point, Preeti, that if they are collectively tried, then how is it that the punishment is different? But obviously the criminal intention, and let me put a very simple example for the benefit of your viewers. Say, for example, if I hide a criminal, potential murderer in my house, and I tell him that you wait here for an hour and you'll have your victim in the next 1 hour coming in the opposite building. And I hide him. He actually goes out after an hour and he murders. So I become an accessory before the fact. So my criminal intention is only to the extent of shielding. But the one who actually committed the murder, so the gravity of the offense is more.
Okay. No, fair point. You're saying the gravity is more, but it needs to be still proven in the court of law because they've been charged under a draconian, which you yourself accept, law like the UAPA. Right now, even the investigation is not complete. The witnesses haven't been examined, and there is no framing of charges yet. I want to bring in Aman Lekhi and Dushyant Daveji into this conversation, but Aman Lekhi, quickly, what's your purview of the judgment today, sir?
Well, I heard Mr. Raju and whatever I've read of the judgment. I don't agree with the judgment. I don't in any way share Umar Khalid's political point of view. My issue here is with regard to the process which I'm going to comment and the framing by the Supreme Court of this particular order, because that is where I think the error comes in. One, I feel that the court has deferred more than what is necessary to the prosecution. Two, I think the court, to the extent it has used terms that delays cannot be trumped, is overstating a principle without defining its content, which have consequences in bail jurisprudence beyond this particular case. And three, the animating premise of this particular section, which is mechanically and ritually cited to deny bail, is missed altogether, and the Constitutional Court is duty-bound to examine that particular animating premise. I do not know whether that point was argued at all or not. But the animating premise, when you talk about prima facie, the animating premise will take into account not just necessity, which Mr. Raju said, but proportionality and temporality. And these aspects have been ignored altogether by this particular judgment. Without going into the legality of it, I want to flag one point Mr. Raju said. And just to clarify, you are saying that witnesses have to be examined for charge. Witnesses don't have to be examined for charge. Witnesses are examined when the charge sheet is filed. The charge is framed by the court. There is no investigation which is to be done after the charge sheet is filed. But that's it. That's not very relevant. What Mr. Raju said was this is delay. Now, admittedly, there's a High Court order for the delay. Now, this is again where the framing comes in. What stopped the Supreme Court to pass a simple order that as far as the petitioners are concerned, they are not entitled to bail because of the persistent conduct of delay? Now, the Supreme Court does not say that. The very people whom Mr. Raju is saying is responsible for delay, wrong, as far as the process is concerned, which disentitles them for bail. I've been given the liberty to renew this 1 year from now, notwithstanding the fact that the star witnesses have not been examined. That means in 1 year from now, what Mr. Raju said, that this is going to be incentive for them, that they will not delay. But this is not what the Supreme Court is saying. This is Mr. Raju's reading of what the Supreme Court has said, again, the framing which is wrong. That means notwithstanding the conduct continuing, hereafter, what has happened till now, even if the witnesses are not examined, then they're entitled to bail. Now, my simple question is, if they're entitled to bail 1 year from now, notwithstanding the fact that the star witnesses have not been examined, what stops the court from granting the bail today? Now, this doesn't make sense to me. And that is why this entire framing of this particular order, in my opinion, is something which ignores that as far as the process is concerned, the process becomes punitive. And when the process becomes punitive, the person, as far as I have no sympathy, if the allegation against them is correct, no sympathy at all. It's a very serious allegation. But then, by reason of an order like this, you discredit the process and in some way make a martyr of the accused. So that is a system which in fact works to the disadvantage of the country, whose interest Mr. Raju is invoking, because the person who should be punished, what should be the outcome of an offense? The outcome of an offense is punishment. Punish the person for what is done on proven guilt, and not speculate about the guilt and discuss upon issues extraneous to the matter. And that is where I think we have utterly failed. And it's a spectacle which is unbecoming of the mature legal system that we have.
Okay, I want to bring in Swapnil Kothari because he seemed to be shaking his head vociferously and not agreeing with what you're saying. Mr. Kothari, go ahead, make your argument, sir.
On a couple of points, I do agree with Mr. Lekhi, but, as far as the entire process being punitive is concerned, I beg to differ because there is a certain law that has been laid down. It is a legislation. UAPA is a draconian legislation. The presumption of innocence gets obliterated to a certain extent as far as, it's equivalent to the income tax law, or where I have to show that I have not evaded income tax, howsoever absurd it may be found if I draw that comparison. But as far as the point is concerned that the Supreme Court erred in following this process. The delay is there. The delay was at the instance of the people. And as Mr. Raju pointed out, that more often than not, we are the advocates who push for delays and who push for adjournments because we believe that if we were to argue this case at this point in time, perhaps it would not yield the favorable result. Now, 1 year from now, I do not know what is going to happen, but obviously the speedy trial has been recommended. If the trial goes through, then we'll have some judgment, hopefully soon, at some point in time. Now, if they were to apply for a bail a year hence, I don't know whether they'll get bail or not. But Preeti, one of the things that I want to point out for the benefit of the viewers is that when serious charges are levied against an individual of this nature, or 2 individuals or 7 individuals of this nature, and if a certain culpability to a certain extent is shown as a prima facie case, then it is a little risky to let the person off on bail. However stringent the bail conditions may be, he could tamper with the witness, he could escape the country. A lot of things could happen. You've had people who've gone to and then obviously, you have the Fugitive Offenders Act. That doesn't come into the picture when it comes to this kind of a criminal legislation. So that is where the Supreme Court must have thought that as far as these 2 individuals are concerned, and if there is a lengthy judgment, normally if you would notice at 10:30, if you start the judgment's reading with a couple of relevant paragraphs is out in 5-10 minutes and we know the judgment. But the court went on and on for about 35 to 40 minutes because it realized the gravity of the situation. It realized that it has to come forth before the public and say these things. So that is where I believe that this judgment, all said and done, is an appropriate one. We can argue on many things till the cows come home, but as far as, the common man needs to understand that justice is not only done, but it is seen to be being done.
All right. But Mr. Kothari, it's been 5 years and the cows still haven't come home. So that in itself is a blot in the judiciary that the trial hasn't begun. But all right. Okay, I want to... Mr. Lekhi wants to come in. Go ahead, Mr. Lekhi.
I just want, you see, that's the 2 issues which Mr. Kothari missed is one, he has not responded to the fact what is the animating premise, and I had dealt with not just necessity, which he's constantly emphasizing, but proportionality and temporality. You're dealing with temporality, and proportionality comes in too, but the Supreme Court has not touched. 2, notwithstanding the fact that this particular provision is, as he says, draconian. Because it is draconian, and we are before a court, which in the overarching reality of Article 21, the interpretation has to be in some way consistent with the constitutional sentiment, because the constitutional sentiment overrides the statutory enactment and in some way animates it. And this particular synthesis is absent altogether in this particular thing. And that's one thing which Mr. Kothari mentioned was that as far as the provision is concerned, you have to say, okay, if it is made out. Now, when it is made out, what is important is what the prosecution says is provisional, it's not determinative. And the mistake the court has made is by treating it as conclusive. Because when it says this, I'm not saying it's guilty, but I think there's a prima facie case, in any case, that this is structurally wrong. That's why I'm saying the problem with this judgment is not we may debate whatever we are. Actually, the problem with the judgment is the framing. And the framing of the judgment is going to cause, because in matters of moment like these judgments have to be decisive to settle the law for the future, because that is integral to a rule of law process which brings in predictability. So precision is important. And I find doctrinally, this is an imprecise judgment, because doctrinally it's imprecise, because insofar as the terms are concerned, the terms have not been elaborated the way they should, with the fine distinction that they require, particularly the impact it has made on something as sacrosanct as liberty. My objection, let me repeat again, as far as I'm not a votary of what Umar Khalid or the other, or Sharjeel Imam do. In fact,
so we understand you don't have to draw that distinction. Fine, we got that point in the word
yes,
go.
But point is, why I'm emphasizing that? Notwithstanding that, because this is what, notwithstanding that, what is more important is the process. Because there can be a wrong accusation tomorrow. And if the wrong accusation is grave, you will not look at the accusation to deny bail, you will apply the process to consider it. And we have to look at the process, and this is where I personally think there is a problem.
Okay, all right. Let's take final comments. Go ahead. Mr. Kothari, make your quick point
Yeah.
and we'll take a quick point from Mr. Lekhi. Go ahead.
Article 21, no person shall be deprived of life or liberty except by a due procedure established by law. Mr. Lekhi knows that, and he must have argued a million number of cases. He is saying that there is a constitutional morality that he's pointing at, and the Article 21 seems to have been effaced a little bit because of the way this whole process has been considered. And he's not, obviously he's saying that bail possibly should not have been granted, but the reasoning should have been different from what I understand from the way he's, emphasizing on this point. Preeti, my short point is that Article 21 was considered, the procedure was there. There is a procedure established by law, which is UAP Act. What Mr. Lekhi is suggesting in the grand scheme of things on a different day, maybe over a cup of tea, I may agree with him. And I may say that, the UAPA needs to be changed. Then remove 43D5 totally. Remove the words for prima facie at all from that consideration. Then I'm absolutely on par with the fact that, yes, this judgment is flawed. But as long as the Supreme Court, and Mr. Lekhi will agree with that, and possibly any other lawyer would agree that the job of the court is to give a purposive interpretation, as is to interpret the law and not to refashion the law as per its own whims and fancies. So be it, even if it's the Supreme Court, if it's Article 141 binding on the law as the law of the land, you need to follow the law. If the law says X, Y, and you may or may not agree with it on a different day.
All right, I want to get in Mr. Lekhi for a quick point. I just want to give equal time to the both of you, and then we're going to quickly get into a break. Go ahead, Mr. Lekhi.
No, nothing. As far as I'm concerned, I made my point. I mean, my problem with the framing of the judgment, because the framing is wrong, I don't trust the outcome. And as far as the outcome is concerned, I personally feel the outcome should have actually been different had it been properly framed. And at least where all of us are concerned, I've got to get an idea as to what is it that we have to actually apply in the future cases. And this is this dubious nature, which in some way is the most deleterious part of this particular order. I personally feel there's more a sentiment over here than a reasoning, and we are being influenced more by the gravity than by the principle on which we have to decide criminal matters.
I appreciate both of you for joining us. Thank you for giving us your point of view. I want to quickly move on to the other story that we are tracking very closely, which of course is parole given to Gurmeet Singh. He heads the Dera Sacha Sauda. You can call it what you may, a cult or a godman or a self-styled godman. Well, he was given parole 15 times in the last 4 years. And we did ask the Haryana Chief Minister that why has he been repeatedly granted parole? Cornered by the media, Chief Minister Nayab Saini chose not to engage, abruptly ending his briefing. All right, we're going to cut across to that reaction of the Haryana Chief Minister. Many seem to suggest that this is comparing apples and oranges. At one end, you have a UAPA case against Umar Khalid and Sharjeel Imam, and that is grave. That talks about sedition, that talks about anti-India activities. On the other, even though it's an archaic law and that is being debated in court, contested in court. But on the other hand, you have a convicted, mind you. That's why maybe you need to draw comparisons. He's convicted of raping 2 women. He's facing charges of murder. Convicted meaning it has been established that he raped 2 women. He's facing 20 years of prison for that. So maybe in terms of UAPA and rape charges and rape conviction and murder charges don't seem to match, but the sheer fact that in 4 years he's been granted parole 15 times, and today once again for the 15th time for 40 days. This was the reaction of the Haryana Chief Minister when we questioned him about the parole of Gurmeet Singh.
सर राम रहीम को लेके बहुत बड़ा बवाल है, आपने लगातार बोला है, लेकिन
मेरे ख्याल सवाल नहीं रहा, वो माननीय कोर्ट का काम है। थैंक यू
सर राम रहीम को लेके बहुत बड़ा बवाल है, आपने लगातार बोला है,
लेकिन मेरे ख्याल सवाल नहीं रहा, वो माननीय कोर्ट का काम है। थैंक यू।
All right, let's cut across to Punjab, get you the latest. Law does not seem to be in order where Punjab is concerned. In less than a month after a kabaddi player was shot dead during a match, now an Aam Aadmi Party Sarpanch Jarnail Singh was shot in the head by unidentified killers at a resort in Amritsar. CCTV shows chilling images of 2 unidentified men entering a wedding venue and approaching Singh, who was seated amongst the guests. Without warning, one of them holds up a gun to his head and fires point blank. Then the second killer also opens fire at the same Aam Aadmi Party Sarpanch. You can see Jarnail Singh collapse instantly and the assailants flee within seconds, even as wedding guests look on in shock. The victim was rushed to the hospital where he succumbed to injuries. According to the preliminary probe, the attackers showed no attempt to conceal their identities despite the presence of dozens of guests. Just a month ago, in fact, a 30-year-old kabaddi player cum promoter died after unidentified gunmen opened fire after he arrived with his team to take part in a tournament in Mohali. Kamaljeet Sandhu is joining us live with the latest incident where the murder of a Sarpanch in Amritsar is concerned. Kamal, what more can you add? What was the motive behind this killing? Have the killers been identified, apprehended?
Well, incessant killings putting pressure on Punjab police. Jarnail Singh killing was one of them. And obviously, the way you're talking about it, the CCTV is a clear giveaway that there's no fear of police. And that is why unmasked men enter the wedding lot. And that is where they kill on point blank. Now, what we know about Jarnail Singh is that he is a Sarpanch from Waltova in Taran. Now, what has been stated by the gangsters, at least 5-6 of them, including Dolly Bal, this also includes the Vinder by Miha gang, that he was after one of the gangsters who he tried to demolish the house. That is one of the allegations which was being leveled. But clearly, there have been instances, at least 2 to 3 in the past, including the last one in March 2025, where his car was attacked. He was ambushed, fire was shot, but he miraculously escaped. Then thereafter, this is where he was targeted at a wedding. Now, that doesn't say much about the law and order, where we've seen killings take place every other day. We've seen the opposition parties up in arms, be it Sukhbir Badal, be it the BJP's Fateh Bajwa, Pargat Singh. So all of them have been talking about it. But clearly, when we spoke to Punjab police, they've been investigating the angle. They're also saying, as far as the national average per lakh is 450 per lakh of killings taking place or crime taking place. Punjab that way fares better because it's 225. Okay. But the sort of attacks and spectacular short arm weapons being used, pistols being used, some of them coming across via drones, several of the nodes or her handlers who are sitting abroad and giving guns to first-time users. Several of them are unidentified at this point of time. But yes, technology being used, CCTV being used, all this is being done. But little to avail because remember, election is just 1.5 years away and a lot of killings and those two dastardly ones are taking place in Punjab.
Thank you, Kamal, for joining us with that quick update. That's all the time that we have for